Good morning. We're going to call this meeting to order. A quorum is present. We have our, I want to welcome to the first meeting our new principal, Mr. DeMassey. Welcome. We also have our parent liaison, Mrs. DeMassey. The first item up on the agenda is the adoption of the agenda. Board members, are there any changes? No changes? Is there a motion to approve? Is there a second?
Second.
All right. All those in favor of the adoption of the agenda state so by saying aye. Aye. Opposed? Passes unanimously. Real quick before I get to consent agenda, we've just received some community comments which will be coming up shortly. So if you do have a comment, whether it's community comments or an agenda item, please make sure you submit it as soon as possible because otherwise we're closing out. All right, meeting minutes under the consent agenda. Are there any changes that need to be made on meeting minutes? The only change I have is for the July 8th organizational meeting. If we could add where we did the election of officers, which that's what it specifically states in our bylaws, but just so it's clear, if we could add the staggered terms so that it's clear who's got how many years, and for the record, it's not term limits. So if we could just add that, that's my only change for the minutes. Any other changes? If not, is there a motion to approve the consent with changes?
Motion to approve consent with changes.
Is there a second?
I second.
All right, all those in favor of the consent agenda with changes state so by saying aye. Aye. Opposed? Passes unanimously. Okay, the reports of officers and standing committees. I will begin with a brief president report, and then I will be calling our attorney, Jeff Wood. But the first part of it is just to give an update to the board and to the public who's here today. MCA versus Joseph Baird. On Monday, August 3rd, 2020, a circuit judge in Hillsborough County denied Joe Baird's motion to dismiss. After she listened to both sides during a hearing in May, as well as being provided pertinent documents and affidavits, she determined there was enough evidence to send this case to a jury trial. The judge also stated that MCA is entitled to recover attorney's fees. This is great news for MCA, and we want to thank our legal team for their hard work and look forward to seeing this through and ensuring justice for MCA. The other case, MCA versus CCPS, as you knew, we had a declaratory action, and on July 8th, 2020, MCA dropped the suit against CCPS because MCA accomplished its goals through the modification of the charter by the CCPS board. I just want to point out that this lawsuit would not have happened had it not been for CCPS continuing to make an issue about Hillsdale College and MCA's charter with CCPS. Again, we are thankful for MCA's legal team for working on behalf of MCA with our best interest in mind. With that, I am going to get Mr. Wood on the phone. Good morning, Mr. Wood. You are on speaker if you want to say hi to everybody.
Good morning, this is Jeff Wood. Good morning, everybody.
Can you all hear him well back there? Excellent. Okay, so we have you on today's call because, as you know, on August 6, 2020, John Fishbane sent MCA's counsel a letter which claimed that MCA continued to violate and disregard the terms of the mediation settlement agreement, MCA policies and procedures, the charter agreement, and Florida and federal law. He reported that the CCPS board voted unanimously to put MCA on probationary warning status through March 1st, 2021. In light of this, I reviewed the charter agreement again and the Florida charter statute, and nowhere do I see probation on warning status. So Mr. Wood, by what authority can the district place a charter school on probation?
we researched those issues too. There's nothing we found which allows for the district to put the school on a probationary status. Back in 2011, there was a clause in the statute that did permit a probation status, but that has long since been removed. And we've actually advised both Mr. Fox and Mr. Fishbane of the current status of the law.
And haven't you made attempts to sit down and meet with Mr. Fox and Mr. Fishbane to get any issues or alleged issues resolved since they continue making false accusations against MCA?
Yes, we wrote a letter to them on June 25th requesting that we meet to go over the items that were set forth in our 20-page rebuttal that we sent on June 5th. And we never got a response to that. And then we asked again right before the last board meeting on July 24th to make sure that all of our letters were part of the CCPS board agenda. And my understanding is that they ignored that letter as well.
Mr. Wood, I just have a quick question. This is David Bulduk. On that June 25th letter that you sent to Mr. Fox and Mr. Fishbane requesting a meeting, I believe that you asked for to respond within 10 days, just a simple question, will you meet with us, yes or no? And Mr. Fox, I believe, asked for an extension just to respond yes or no, and then they never responded. Is that accurate?
That's correct. I got an email from Mr. Fox on or about July 3rd asking for an extension, and then did not hear back from him, which prompted the letter that we sent on July 24th.
Thank you. Just so the board members know, yes, I have questions today. As you hear things from Mr. Wood, you want to jump in and ask questions like Mr. Bulduk at any time, please feel free to interrupt and ask a question. Mr. Wood, at the CCPS board meeting on July 28, 2020, board chair Stephanie Lucarelli asked Fishbane if we have received any responses to any of those variety of letters that were sent out. She was referring to the attorney letters. Here was Fishbane's response verbatim, quote, I had sent to you, I believe, one or two of them. I believe there were 2 responses and they did not address the issues. I have in my possession 5 letters from counsel, not 2. Did MCA's counsel directly address the issues brought forward by Fox and Fishbane? And can you give some examples to share on the record, please?
Well, sure. As I said before, we sent a 20-page rebuttal letter to counsel. Some of the items that were included in that were government and sunshine law violations, emergency meetings and special meetings, issues regarding our minutes not being properly prepared. We addressed their allegation regarding violations of the First Amendment and governmental access. We addressed auditing financial statement questions and financial concerns regarding excessive litigation. We also addressed the board professionalism and civility and other various concerns. So either they chose to ignore our response and didn't want to meet because they're not interested in hearing our position. But I would think that letter substantially applies to a significant amount of the details set forth in the August 6th letter we just received.
Yeah, I actually went back and looked at the earlier letters, the August, September letters that Fox had sent, and the response, and our attorney at the time, Michael Coleman, responded, used the exact same headings, responded to every allegation. So it just concerns me that not only did Fishbane lie to his client and say that maybe they received 2 letters, he then tells his client that we have not even addressed the issues. And I find those to be just completely flat out dishonest lies.
I just have one question. Can we confirm how many response letters have we sent, whether it be from Michael Coleman or Rock McLean Sabar or Trip Scott? How many responsive letters has the school sent to?
It's
At
at
least
least
5?
At least 5, if not more.
Okay, so when John Fishbane was responding to Stephanie Lucarelli saying, yeah, I've sent you 1 or 2, he is essentially telling his client, the school board of Collier County, that he has not provided them with all of our responses.
All right, so the other thing I want to go through today is the that letter, and I want to go point by point. If we could get on the screen, I believe Mr. Steer, it's in the file. I hope it's in there. The probation letter. And if we can start at page 2, scroll up to item number 1, and I'd like to go through these numbered items in the letter. And at this time, I'll ask Mr. Wood, if it's relevant for staff or a board member, I will ask a question related to every one of these items. So we're going to go through that right now. The first item, it says here that all board meeting minutes over the last several months that have not been prepared and approved, including minutes and all regular special emergency meetings, must be undertaken, completed, and approved by the board. This question is to Ms. Smith. You have worked closely with the MCA board since the MSA, the Mediation Settlement Agreement. Are all of the meeting minutes up to date as of today?
Yes, all the meeting minutes are up to date and they're on our website under leadership.
Okay, thank you. Mr. Wood, is there a law that requires charter schools to complete and post meeting minutes in a specific time frame?
Yes, actually there is. It's not governed by the district, but rather Section 1233 Florida statutes, and also the sunshine laws in Section 286.011. The charter contract also on page 39 has a Section 9A under governance. It states that the board will have at least 2 public meetings per school year within the district. That mimics what's in the statute, by the way. It says that the meetings have to be noticed, open, and accessible to the public, and attendees must be provided an opportunity to receive information and provide input regarding the school's operations. So it's required under state law that the minutes be posted when they're done.
And it sounds like we are in compliance. Mr. Wood, number 2, let's look at this one. All emergency and special meetings called and held to address routine business matters must cease. Emergency and special meetings are to be called for emergency reasons or to address special matters only that cannot be taken up at a regular MCA board meeting. Mr. Wood, by what authority does the district dictate whether or not the MCA board holds emergency or special meetings?
It doesn't. As I said before, the school board does not have authority or the ability to dictate where, when you have your meetings, as long as they're done under the sunshine law. The sunshine law does not mandate that an agency provide notice of each item to be discussed at a published agenda as well. And we actually advised the district of that in the June 25th letter that we sent to them. We gave them the case law that supports that. I'm not going to give it to the board again, but it's in that letter.
Yeah, and we also went through historically that MCA board did not historically have very many emergency and special meetings until last summer when the Fishbane report happened, along with all the other attacks against the school that pushed us to have more frequent meetings. So thanks for clarifying.
That's very similar to, I'm sorry to interrupt,
Yep.
Board Chair. It's very similar to the championship school that just went through a termination process over the last year. Their number of emergency meetings escalated. So it's not uncommon when you're under fire like we are.
That's right. Thank you. Number 3, it says all documents and agenda items must be timely uploaded and linked to the given agenda item and not directing the public to find them on MCA's calendar and made available for public review and participation at MCA board meetings for discussion. Mr. Wood, the MSA clearly states, quote, Mason will attach documents in advance to be published along with agendas discussed or reviewed by the governing board in order for the public to access those documents in advance of the meeting. By what authority does the district dictate where MCA uploads meeting agendas and attachments on its website? And by what authority does the district dictate how far in advance attachments are uploaded? Because clearly the MSA does not specify.
There isn't any authority for that. And in fact, there wouldn't be any authority for what they're asking to do in the MSA had you guys not agreed to it. So the answer to that question is there isn't any.
And just for the record, an email was sent out to the MCA community informing them where to find agendas and attachments, which we moved to the homepage, which is the most accessible place to find it versus where it was originally supposed to go, which you'd have to click 3 times just to find it. And at this time, MCA has not received any communications that members of the public could not locate agendas or attachments. I just want that to be clear. Number 4 says shade meetings must be properly held and conducted in accordance with laws, specifically Florida Statutes 286.011. Mr. Wood, did Mr. Valles from Rock, McLean, and Sabar work with your firm to ensure MCA's shade meeting was done properly in accordance with all applicable laws? And were you aware of any issues related to the shade sessions?
We had several conversations with Raul regarding his conducting the shade sessions, and we offered some thoughts. I don't want to get too specific, but I didn't hear anything specific about what was alleged to be wrong with how he was conducting them in the first place. But after reviewing, what his process was with him on the phone, we thought that he was in compliance with the Sunshine Act. So without any specifics, that's where we're at.
Okay, thank you. All right, number 5 says IRS nonprofit 990 forms must be brought current in accordance with the charter agreement. Subsequent to the July 20th, 2020 board meeting, MCA's business manager sent Dr. Curtin at the district those for 2018, which is certainly appreciated. Mr. Becker unfortunately could not be here today, so my questions to him, and I sent these to him in advance, are the 990 forms current, and are charter schools required to submit the annual 990 forms to the district, or was this a special request? He said the Form 990 is a tax return for nonprofit organizations and is filed every year with the IRS. The 990 for the fiscal year 2018 was reported for the school year 2018-19, which ended on June 30th, 2019. This was filed with the IRS on January 26, 2020, before the expiration of the extension from the IRS in May. I am not sure if my predecessor sent a copy to CCPS, but I sent one copy to CCPS anyway. Mr. Wood, are we required to send the 990 to the district?
They can ask for it as part of their monitoring function, and if they have, you should comply by sending it. But it does go to the state every year as part of the audit.
And he went on to say that the 990 for fiscal year 2019 is for the school year 2019-2020, which ended on June 30th, 2020. He said, we are currently being audited, and as soon as the audit is complete, we will file the 990 for this year. The due date is November 15th, 2020, and we will also send a copy to CCPS. I want to also point out that I spoke with, through email, with Stacy McCready. She's the independent auditor. We have never missed an audit. So for them to put in here that it makes it sound like we've not complied with laws, which is, again, another lie. In fact, she said our financial health is great. In fact, we have a call today at 2, and like I said, like Mr. Becker said, that's already in the process of happening for this school year. So it's just frustrating and exasperating, just the blatant dishonesty.
Yeah, and I would just like to add on each one of those annual audits, I believe it's required by statute that one of the last sections of the audit, the auditor has to report to the Inspector General, I believe, of the state of Florida of any perceived deficiencies financially at the school, and to outline them. And from what I recall, and actually I sent this to her in writing, and she responded, I believe it was back in April. The Mason Classical Academy has never had a listed deficiency when our audit was filed with the state.
Thank you. So I kind of covered that audit, but I do want to also point out, because they're claiming that we did not, it says the independent compliance audit of the MSA's corrective action plan. Mr. Wood, I have an email from Scott Moore, our former compliance officer, that stated he submitted the independent compliance audit for the MSA, and all the board members received the independent compliance audit. And he submitted it in December of 2019. The district has made this accusation for months that we did not do it and are out of compliance. I do recall you sent in a letter asking about that. Did you get confirmation that it was in fact sent to the district?
No, I never got confirmation with respect to any of the letters that we sent, to be honest.
Wow.
And I would just like to add on that audit of the corrective action plan. It was delivered to, or the final version was delivered to the school, delivered to Principal Vicarious at the time, and Scott Moore on December 5th. They sat on it for 15 days, and then on the last day of school of the first semester, December 20th, Mr. Moore decided to hand deliver it to the district. And while he was standing in the district offices, he called our attorney, Raul Valles from Rock McLean Sabar, and asked Raul and said, "I'm not sure I can hand this in. Do we need to call a board meeting first?" So he sat on it for 15 days, went up on the last day of school of the semester, knowing full well there's no way Mason Classical Academy could call a board meeting on that day, and said, "Can I hand this in prior to a board meeting?" So, and then I was not pleased with that at all, and I demanded that Mr. Moore send a confirmation to all of the board members that he delivered the audit of the corrective action plan on December 20th to the district.
Thank you, Mr. Bulduk. So it's one of two things. Either Mr. Moore didn't deliver it and he lied to the board, or Mr. Fishbane is, again, lying here. All right, number 7, it says the employment contracts of MCA employees, Joseph Whitehead and Gina Smith, as well as any other employees of MCA that contain language authorizing or allowing the receipt of advance payment for work not undertaken or completed must be removed. Counsel for MCA must certify to the district whether or not any such funds and payment were at any time requested by, dispersed to, or issued in any form, whether in whole or in part, to Mr. Whitehead, Ms. Smith, or any other MCA employee operating under any such contract. One thing I want to point out that the district fails to recognize that Scott Moore also had this lump sum payment stipulation in his contract, which was added by Pam Vicarious. He had been employed for 2 months and received that, as well as a $10,000 raise by Vicarious. The first time I saw the contract language was when Vicarious asked me to add her amended contract to MCA board agenda with the lump sum payout. I denied her request because we do not do that here, as it is improper. Then it shows up when Mr. Whitehead emailed Vicarious and copied me requesting his payout, which I then called a special board meeting to address and rectify this egregious and reckless contract language, which was added by Pam Vicarious. I do have questions for staff members. Ms. Smith, did you have an employment contract that gave you a lump sum payment? Could you clarify in the record today, please?
Yes, on 11/21/2019, Mrs. Vicarious presented me with a new contract to sign, which included an option to request a lump sum salary payment for the balance of my contract. I signed this document. I walked away and immediately felt very uneasy about it. I went back to Mrs. Vicarious shortly thereafter, within 24 hours, and stated that I decided I did not want that contract. That's the one dated for 11/21/19. And I wanted to keep my original with no lump sum payment option. Mrs. Vicarious said she understood, and she wanted me to take some time to think about it and let her know by the following week. She said that she would set it aside and not process it until I decided. So several times over the next week, Mrs. Vicarious brought up the issue of the contract, expressing the great benefits of having the new contract and what a favor she was doing me by having that contract in place. She encouraged me to move forward with it, and within that week, Mrs. Vicarious invited me into Mr. Moore's office and closed the door and spoke privately with me in Mr. Moore's office, recommending that we each set up a Valley National bank account, since MCA already has a bank account there, and said that if something happens with the district, then we could each take our lump sum payments immediately, and that money would be transferred over right away. She said it would happen within a day, so there'd be no, need to wait for a check to clear. And that is how I learned that Mrs. Vicarious had also given the lump sum payment to Mr. Moore. I determined within a week that I did not want the new contract. I went to Mrs. Vicarious's office and told her this, and she told me that's fine to see Mr. Moore. I went directly to Mr. Moore's office and told him I did not want the new contract processed. I asked him If he had uploaded it to the Google Drive, he said he had not because he was waiting to hear my decision. It was clear with him, I was very clear with him that I did not want the new contract dated 11/21/19. I wanted to keep my original contract with no lump sum payment, and he stated that he would not process it. I asked him for the contract, and he said that he didn't have it. He gave it to Mrs. Ashley Hamilton, who was currently contracted with the school. She was working with our accountant, and she was coming in. And so she was in the office next door. I immediately went over to her and told her that I did not want that new contract processed. I had spoken with Mrs. Hamilton earlier that week, the day I signed it, telling her I didn't feel easy about it. And when I told her my decision, my final decision not to accept that contract, she said she completely understood. And while I was present in her office, she looked in her folder on the desk for the new contract, but she couldn't find it. She said that was odd because she knew she had it right there on her desk. And she's very organized, so it was very surprising to her and to me that she couldn't find it. She said, "Don't worry, I will find it and I will take care of it." So Mr. Moore and Mrs. Hamilton both understood I did not want that new contract with lump sum payment dated for 11/21/19. They both assured me they would take care of it, and I assumed that that meant it would be voided. So later, after Mr. Moore was no longer with MCA, I found that 11/21/19 contract, the one that I had requested to be voided, hidden in the back of Mr. Moore's desk drawer and separate from all other contracts. Interesting to note, when Mr. Hull became executive director in March and he asked Mr. Moore for a copy of everyone's contract, Mr. Moore provided Mr. Hull with a copy of all official employee contracts. And the contract Mr. Moore included for me was the 10/10 contract, 10/10/19, with no lump sum payment. So in conclusion, the 10/10/19 contract with no lump sum payment was a valid contract for me last year. And my contract this year has no lump sum payment. Thank you.
Thank you for clarifying that for the board today and for the public and correcting the record. My question next is to Mr. Whitehead. Did you have an employment contract that gave you a lump sum payment, and who created the contract changes and signed it?
Thank you. Yes, I did at one time have a lump sum contract option, and the lump sum contract option came with the obligation to continue working under the terms of the contract with just payment being made in advance. It was done approximately in November of 2019, and it was authorized by our former principal, Ms. Vicarious, and signed into effect by our former principal, Ms. Vicarious.
Thank you. This question is from Mrs. DeMasi. On June 2nd, 2020, Dr. Curtin emailed you the following, quote, "As part of our due diligence review of Gina Smith, Joe Whitehead, and Pamela Vicarious's employment contracts, we will need copies of MCA's payroll records for each of them from April 1st to the present. We will also need all accounts payable records with respective to each of them for the same time period," end quote. Were these documents sent to Dr. Curtin and when?
Yes, they were sent to her June 16th, which was when she requested them by.
June 16th, okay. Well, then why, I guess my question is, why are they asking for this stuff in this letter? I don't know, thank you for sending that, I appreciate it. Board members, any questions up to this point?
I would just say that's consistent with never acknowledging documents that we deliver to them.
Yeah, unbelievable.
I have a question for Mr. Wood regarding several of these issues, including the district's failure to respond to our communication with them. I mean, isn't that within itself a violation of the mediation settlement agreement?
Mr. Wood, did you hear her?
I didn't. I apologize. I tried really hard to.
Okay.
Can you repeat it?
She's asking if the fact that the district's not even responding to the communications that we're sending, is that considered a violation of the mediation settlement agreement?
Certainly the spirit of it, which was created in no doubt to try to create a mechanism to resolve disputes between the district and the school. So I would say yes.
And Mr. Wood, Do you feel that's also, I don't know, like a breach of contract or, a better or a different term on the dispute resolution clause that we have with the district in our contract?
Well, I think the mediation settlement agreement is in itself an aberration of what charter schools do when they have issues with their district. I wouldn't call it an amendment to your charter contract, but it certainly is an obligation that both sides need to live up to if they made that agreement. So the problem with the MSA, the mediation settlement agreement, is that there really isn't any teeth in it. Nothing in there says what happens if one side violates or the other side violates. So, to respond to your question, yeah, it would be a breach, but what's the remedy?
Okay. And we'll touch on that in a little bit. I did ask Mr. Becker, who's our business manager, if any lump sum payouts were made to any employee. He said, I started at MCA on April 24th, 2020, and no lump sum payment was paid to any employee. Since then, I also have not come across any lump sum payment to any employee before April 24th, 2020. So I hope that clears that up as well. Number 8 in their letter says, on April 1st, 2020, MCA board member Mr. Bulduk prepared his resignation letter, which letter was posted for public review at the April 14th, 2020 special board meeting. He advised that he would be departing at the end of the school year in May 2020. His letter denotes that this was agreed to through discussion with board chair Ms. Lichter outside of the sunshine. Despite this, Mr. Bulduk has remained in office and recently voted himself to continue on in office as a board member. MCA Council must explain the contradiction in light of Mr. Wilkham having resigned from and having left the board in April 2020. So my question is to Mr. Bulduk. Did you prepare a resignation letter and post it for public review, and did you vote yourself back on the board?
No.
Okay, that's a simple answer because I looked everywhere for this resignation letter and it does not exist, folks. So here is another just flat out blatant lie.
I would like to add too, at the Collier County Public Schools last board meeting when believe it was board member Westbury asked John Fishbane about my resignation letter. One of the questions was it accepted by the board? And he said, yes, I believe it was accepted by the board.
Do you guys remember that?
Yeah, I'd just like to say, as the secretary, up until that point, I never received or had any knowledge of any letter of the kind.
Well, I would also like to add, in the first sentence of item 8, it says, the resignation letter, which was posted for public view at the April 14th school board meeting, and they're on record as saying, Mr. Fox is how they listen to every one of our words, they read every one of our documents that's posted. So where was that posted document? If they have a copy of it, then why couldn't they provide it?
I did request it, still have not received it, and likely won't.
I just think that's further evidence that all of these accusations are untrue by design.
And as we continue on, I think we'll see a pattern here. Mr. Wood, is it a sunshine law violation for Mr. Bulduk to communicate with me some personal concerns and sharing with me his intent to resign, not resignation, when this would not even come before the board for a vote?
That's very interesting. I think there's a common misconception out there that every conversation between two board members on a public body is a sunshine violation. I mean, you could ask him what Starbucks coffee he has, and that's not a sunshine violation. So from the start, not every discussion between board members is subject to sunshine. It only is subject to sunshine if it's a matter that could come before the board for a vote. Now, resignations don't need a vote. You don't have to accept it or reject it. The board doesn't have that authority. If someone wants to resign, they just resign, and the board has to deal with it. So I'm not sure where Mr. Fishbane's going with this.
Yeah, and I would just like to add, I think it was at, I'm not sure if maybe it was the April 14th board meeting that Mr. Wilkham notified us 10 minutes before the meeting that he was resigning, correct? And he actually spoke about it right before the meeting started. And there was no vote to accept it.
No. All right, we're going to go on to item number 9. It says here, at the apparent MCA organizational meeting, which was noted under the category of new business at the July 8th, 2020 board agenda as election of officers, MCA board members voted themselves into office and disregarded the staggered term provisions set forth in paragraph 7 of the MSA. The staggered terms policy was to have been prepared and put into place by October 15th, 2019. This has never been done, he says. Never been done. Of the persons on the board at the time, exclusive of Mr. Wilcom, one board member should no longer be on the board as of the date of the recent apparent organizational meeting. In light of Mr. Bulduk's resignation, this would mean either Ms. Lichter or Ms. Miller-Malinovich will need to depart from the board immediately. What's interesting is we have notified them because they've raised this issue before, and we corrected the record. Here are the meeting minutes, and it's on the agenda, September 26, 2019, new business, item H, board members decide staggered terms. If you go to the meeting minutes from that meeting, it says clearly, motion to approve staggered terms of board members, the 2 longest standing board members in the 3-year class, the board member having served next longest in the 2-year class, and the newest board member in the 1-year class, and in parentheses, it says, not term limits. Okay, just want to clear another lie up, because it says here that it was not done. So when they've made claims that we cannot follow the law, we violate MSA, as you can see, ladies and gentlemen, we're only on item 9, we still have to get to 14, and every single one so far has been a lie.
Also, on the manual, before I was a board member, you can find it. It's in the information right on there. Before I became a board member, anyone can look that up. It's already on there.
So, Mr. Wood, based on that information, did MCA comply with the requirement in the mediation settlement agreement?
Absolutely. This one absolutely befuddles me. I really don't understand how an attorney can misinterpret term limits for staggered terms. It's mind-boggling. I don't know of any charter schools, none that I represent anyway, that actually have term limits. It's hard enough to find a board member to go ahead and have someone agree to do this and then say, yeah, but your lifeline is only for 5 years and then you're out. That's a hard way to recruit anybody to do this volunteer job. And I would also say that for several years now, public school boards have been under attack to have term limits, and they don't have term limits. So that's all I have to say about that.
I think they've also been requested to provide an audit, which they never have in this district.
And that's correct. All right, number 10. So the district will insist on MCA board members and employees' civility, professionalism, and responsibility in its day-to-day dealings with parents, the community, and one another. The principles of civility, professionalism, and responsibility are set forth in MCA Board's pillars of character development, social media policy, and so on. Paragraph 4 of the MSA, providing that the board was to publicly attest through resolution that it would affirm and adhere to MCA policies, which the board did do and complied with the MSA. But they try to make it sound like we didn't. These principles and policies have been continuously ignored and violated. He goes on to say that since the approval of the MSA, board members have engaged in a pattern and practice of acting in a derogatory manner by speech or action toward parents who had questions or disagree with board members, members of the community, district personnel, and so on. In the CURE document issued on July 2nd, 2019, and in the Coleman report issued in November 2019, Ms. Lichter and Ms. Malinovich agreed to discontinue engaging in social media comments, lack of civility, and put downs of others, and so on. They and other board members have not honored their word. Board members' social media attacks and abusive comments directed toward MCA parents and former parents, members of the community, and others, including supporting other persons' attacks as found in the hostile takeover of MCA, whose founder appears to be Mr. Lichter, as well as, which I have no idea why he has anything to do with this document, as well as other social media outlets, must cease immediately. These are contrary to the above referenced MCA policies, norms, and the MSA. In this context, the board collectively, through resolution or motion, must publicly disavow as a board such negative comments as set forth in the hostile takeover and other social media outlets, including but not limited to Facebook, Instagram, and so on, toward MCA parents, former parents, students, employees, and members of the community. This will allow for a clean slate moving forward. Mr. Wood, has the district provided even a shred of evidence related to this issue regarding board members?
No, the only evidence that we've seen is what he cites in his letter. I mean, obviously, we're aware of the ongoing social media messaging, if you will, both for and against the school. What we find interesting is that, you know, in the next paragraph, not to move ahead too much, Board Chair, they're talking about First Amendment rights for parents, and yet they completely want to ignore the fact that the board has their own rights to say whatever they think, whatever their theories are. Now, again, we get into the issue of whether or not this violates the MSA, and whether or not, you know, it's being done as a defense rather than, you know, an offense. In this circumstances, we're kind of splitting hairs because there's really no remedy in the MSA to begin with.
But Mr. Wood, I have yet to see a single piece of evidence where these statements are true about board members and postings. What I have seen are the opposition pages against the school's leadership have been abusive and derogatory, demeaning, hateful. I mean, is that what he's talking about? Because that's not anyone sitting up here. But at this point, I have not seen any examples. They haven't provided not one. So to make these accusations, I find them to be reckless and defamatory. And I appreciate you addressing item 11 because I do also feel this is a First Amendment issue. And I also feel it's a way for Mr. Fishbane to try and silence us from getting the truth out. All right, I'm going to move on to 11. It's talking about MCA websites. I just want to make this clear, Mr. Hall, MCA has one official website, is that correct?
MCA has one official website, that is correct.
Okay, just want to make that clear that if there's other websites that, or Facebook pages, that we have one website and one Facebook page. So, Mr. Wood, I do want to ask you though, in terms of individuals posting abusive and inappropriate language on a children's school's Facebook page, is there a violation to remove those comments? It seems like, you know, that would be ridiculous if we're not allowed to remove stuff like that on a children's school Facebook. But what say you?
Well, there's immunity for that kind of stuff that goes on public sites. And not to get too inside baseball, but it's at 47 USC section 2030 C2 and provides for immunity for public sites that take good faith action to restrict access to content that the provider or user deems obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. So there's federal law that puts responsibility, if you will, on the board to make sure that those type of messaging on social media is removed.
Isn't that interesting? Yeah, did you, can you cite that again for Ms. Malinerich, where that came from?
Sure, 47 USC, section 230, C2,
Thank you.
in brackets.
All right, so number 12 says revised parent contracts, including the one prepared after the MSA went into effect, must be sent to Dr. Curtin. I mean, to me, Mr. Wood, isn't this just, like, why is this even in this letter? I mean, I know our new principal is having regular communications with Dr. Curtin. It sounds like things are going very well as far as the open dialogue between the school and the district. In terms of that, why couldn't that just be a simple request? I mean, why is this in an attorney letter?
That's a great question. You know, in order to answer that, I have to know the context of when this came to Mr. Fishbane's attention, why he felt that it needed its own paragraph. It sounds to me like you guys have complied with every request that you got from the charter school office, and your issue isn't really with the charter school office getting that information. So there might be a miscommunication between Mr. Fishbane and the charter school office with respect to this item. It's clearly, though, any kind of parent agreement or parent contract or letter does get reviewed by the district and is subject to approval based on the law that's out there on parent contracts.
Okay, let's get to number 13. This was Mr. Hull may not serve as MCA's executive director and must step down from that position. The charter application does not provide for such a position, which was arbitrarily and secretly created. The application, which, let me correct that, this was done at a public board meeting on March 17th, not in secret. So again, dishonest, defamatory, to say the least. The application document clearly delineates that the principal reports directly to the MCA board. A new MCA principal has been hired, is now in place. Mr. Hull's contract has identical language relative to his duties and responsibilities to that of the recently terminated principal, Mrs. Vicarious, thus demonstrating that he was to be the real principal. Not true, and now the new principal has a very different contract. The creation of an executive director's position for Mr. Hull was in violation of the CURE document, the MSA, and the charter agreement into which the application is incorporated by reference, and so on. Mr. Wood, by what authorities does the district have to dictate who the MCA board employs? That's my first question.
Yeah. Okay, well, they don't. Outside an agreement that you guys reached, they accepted your application and it showed what positions you were going to hire for, but they don't have any authority to say you can't use a person unless they have an issue with the person's certification, unless there's a good faith basis to say this person is not qualified to serve in that position. And I haven't heard anything since we've been representing the school regarding Mr. Hull and his abilities. So I'm not sure where that's coming from. I will say that the MSA does say that you're going to hire a new principal, but I didn't see Mr. Hull's name in there at all in terms of him being removed or why he's being attacked personally. It's beyond the pale.
It is beyond the pale.
Mr. Wood, how many districts do you think you've dealt with other than Collier County?
Probably about a quarter or a third of the districts I've had some interface with on compliance issues. And if you're going to ask me if I've ever seen anything like this,
You read my...
There's some situations where, for whatever personal reasons, districts have said that they want to see certain personnel removed, and they overstep all the time. That's what districts do sometimes. They get involved in wanting to micromanage the school, and that's not their responsibility. Their responsibility is to monitor the school for compliance, not to dictate to the school who they should employ and who they shouldn't.
Well, I think part of the problem, Mr. Wood, is that Mr. Fox keeps citing the statute about the school board controlling all public schools, and he must not be aware of the charter statute that specifically says that charter school boards are, like you said, to monitor. They're not to control. I know that's what CCPS wants, but that's not what the law says, and I think Fox has been doing the board a disservice by citing a different statute.
And in fairness to that point and to the comment that Mr. Bulduk made, I have seen districts actually try to put language in there that talks about controlling certain positions and being able to veto a candidate for some of the leadership positions. And we've challenged all of those, and we've had great support from the FDOE on that as well. You can't have autonomy and flexibility when you're being dictated to and told who you should hire and not.
I just want a quick clarification because I couldn't hear with the mic. How many districts, again, did you
say
There's
involved
46 districts. I've probably been between a quarter and a fourth of those districts. Just remember this, that not every district has charter schools.
And just also want to clarify, Fishbane must not be aware that the use of executive director was not only in our former early documents, but it was in the amended charter agreement, which the CCPS board voted and approved unanimously on June 9th, 2020. So again, this just complete dishonesty and yeah.
I would say this, that, and I'm sure you guys are working on this, there should be some job descriptions for those positions. And whether it's principal or executive director, so that there's clear lines of responsibility.
Yes, of course. And we're going to go to number 14, which says the district is aware of toxic mold issues that are of concern for health, safety, and well-being of MCA students and staff. These issues were openly discussed at a public meeting when the Director of Facilities for MCA, Mr. Walkowitz, was questioned by MCA board members about it. Mr. Walkowitz was later terminated from his employment at MCA, apparently for making such information public. In addition, apparently hot water lines are needed on the school building's second floor, which have not been installed. And the district's requesting a report, which is fine. But I want to say that I personally spoke to the health inspector about the hot water lines, and he informed me that there were no issues with the water lines, so that came from the health inspector. I mean, Mr. Walkowitz is not a health inspector. On March, I also want to remind everyone that on March 17th, 2020, Pam Vicarious informed the board at a public meeting that the facility was in great shape. She commended Mr. Walkowitz and stated that in the event the students and teachers would return from the pandemic, the building would be ready, and never alerted the board to any issues whatsoever. Then the board was sent a report where Mr. Walkowitz, just a couple of weeks later, said that he found mold. Vicarious was aware of it, but at that time when we questioned him on it, they still had not had a licensed mold inspector in the building, and I wondered why was that not the case.
No, I would just like to add, the timing of that. So at the March 17th meeting, Principal Vicarious, commended Walkowitz and said the building is in fantastic condition. There are no issues whatsoever. And then I believe Mr. Walkowitz's letter is dated April 13th. So within less than 30 days, all of a sudden, there's just these massive issues that have been ongoing for 5 years.
Yeah, because that was also the meeting Mr. Hall was brought in as executive director. Speaking of Mr. Hall, are you able to speak on this issue related to the mold found and where things are today?
I'm able to speak on that issue a lot, but I'll keep it very brief. I would say the different roles and responsibilities between executive director and principal are such that the executive director would take a more active role in the facility maintenance. So as soon as I heard that there was a mold issue in this school from Mr. Walkowitz, I think what might have set everything in motion, maybe some of his hostility, is my question was, if there's mold, if there are problems, big problems in this school, why are you painting so much? That's kind of what the catalyst was. And you can see right up here, actually, right above, you see the difference between the blue and the brown? That's where it stopped. So it's kind of symbolic to me, this brown paint that's in this room right here and that stopping of it right there, because as soon as we found out about it, we went full force to attack this issue if there was one. And companies, professional, highly qualified companies have been brought in. Every square foot of this 72,000 square foot building has been inspected by those highly qualified professionals. Any bit of mold has been remediated, removed. Any piece of drywall that's been taken down for inspection has been replaced, mudded, sanded, and ready for painting. Painting begins today. There's no mold in here. When the issue was brought forth, we attacked it, and that's where we are right now.
Yeah. No, I'm sorry. And I want to add one thing on mold being present in a building from a water leak. And I go back to Hurricane Irma, post-Hurricane Irma. I represented a number of condo associations, and so we had a number of calls with the insurance companies on the claims and things of that nature. And a couple associations asked the questions to some experts. They're like, well, what about, there's mold in the attics, and the builders and the insurance company experts said, look, this is Florida. When you're building a condo or any type of home, you're exposed for a certain period of time. You're going to get rain in there. Then you close it up. And he's like, every building, practically, every condo building in the state of Florida probably has mold. There's some moisture that got in, and when it does get in, and then you find out about it, you remediate it. So this is not unusual at all.
Can I also, I'm sorry, go ahead.
Not only is every condo building, but probably every single one of your homes. I'm an insurance agent, and I can guarantee you that there is moisture because it's Florida. It's so humid. It is very normal, but when you see it, you need to fix it. So, but it's very normal. So.
And it's mainly from the building envelope, right? So you can see around the windows over here where the water has been leaking in there, and it's now the building has been fully sealed. It's been painted on the outside. You might even see the new blue windows on the frames of the windows when you drove into the school. The whole thing's been painted and sealed. And again, inside painting begins today because there is no mold. I would also like to say that Stanley Walkowitz was not terminated. He was not terminated. Thank you.
I was going to address that question with Mr. Whitehead because Fishbane makes that claim. Again, I find it defamatory that he makes another claim that's just simply not true. So can you speak on that issue, please?
Yes, for the record, this is what took place, and I'm following up on what Mr. Hall just explained to us. During the mold remediation process as we began, and Mr. Hall asked me to provide oversight of that during this whole time. After we started looking at the more comprehensive issues of what it takes to maintain a much older building, it was on my suggestion to staff and our director that we actually consider outsourcing the maintenance and the management of this facility to a company that actually does this professionally and has years and years of experience doing this. So after a few check-ins with a few different possible providers, we had a very productive meeting with American Building Management, ABM. They are the provider of facility management and facility care for the other Collier County public schools. So our determination was that we thought that we're at a point in our history for the benefit of maintaining this building to the best of our ability and with the kind of issues that we all face today to maintain sanitation in buildings, cleanliness, to be as germ-free as possible, that we wanted to go with a company, outsource it to a company that this is what they do, period. So we arrived upon an agreement with them. Mr. Walowitz had a contract that extended through the date of June 21st, 2020. When he was notified that we were going to, which I did in person, I notified him that we were going to make a change and we were going to go with an outsourcing plan to a professional company that does building management and maintenance. I notified him approximately 3.5 days prior to the end of his contract. He was actually paid through the end of his contract, and he was given the option of his last days of employment of he could stay and work through those days or he could take them off in a paid leave status to do whatever he wanted to with his time. So there was no termination. What we have is a completed contract, and a person was compensated through the entire end of that contract. There was no termination or interruption of his service.
Thank you for the clarification, and I do want to commend staff for the hard work on taking care of this facility. I think this past year, a lot of balls were dropped, unfortunately, but that's water under the bridge. I think you all did a great job getting this resolved and also taking the initiative to say, okay, how can we, every year I feel like we are always improving as a school. Where can we get even better? And I think it was a wise choice to bring ABM in here. I think it's going to be good for MCA for our future. So, yeah.
And we may have these already in one file or what have you, but I think it would be helpful. I think we've had at least 2 property insurance companies insure the building. I think for the first 3 years it may have been Lloyd's, and I think in the 2 years ago we switched over to the Hanover Insurance Company. And Mrs. Everson can confirm this too. Whenever a commercial insurance company writes a new property, they send in and do a full inspection inside and out, and then advise the insured if there's any areas that need to be recommended to be fixed. So, and oftentimes if the building is big enough, they'll do an inspection at renewal. So I would just like to go back. I would like to suggest if we don't have them, go back to our agents. I think that maybe we're Brown and Brown at first, and then now Roberts and Ryan, and just say, hey, can you send us all the inspections that the insurance companies have done since we've been in the building? I think that would be helpful to have.
For sure, they just to make a note, insurance companies, especially on commercial buildings, they will check. It's an audit. They check and they inspect everything, audit everything, and they make you fix it. Well, recommend you fixing it or they'll cancel you. And then also, they do spot checks after. So it might not be every single year, it could be every other year on the building because it's large. So they don't do it like every year, but they will. If they seem like they want to do it every year, they can. So that's a great way to get some information, so.
Thank you. I had one more question, Mr. Whitehead, because they brought up in here the fire inspection. When was the most recent fire inspection? What were the results?
We had a fire inspection of June of 2020. I actually was present for the fire inspection with the fire inspector. He went through the building and he told us that we completely passed. The process is basically them just checking on any critical areas of the building that keep us in compliance with fire safety codes. And we were given a clean bill of health. We have been every year since we've been open. And it was a very simple process. Also, the same holds true for health inspection. We are open because we are passing and have passed all of the required inspections. So anyone who makes commentary to the contrary is bringing forth false information.
Mr. Whitehead, were you also informed that people were making anonymous complaints against the school with the fire department?
Yes, there was an anonymous complaint that was made in the early part of June of 2020. I spoke to the fire inspector about it. He investigated the situation, completely cleared us of any inappropriate conditions in the school. So, and he did acknowledge that, sometimes fire departments are used that way in a retaliatory fashion.
Okay, thank you. Mr. Wood, I don't know, did you have a chance to review Mr. Walkowitz's letter to Dr. Patton dated June 6, 2020?
Actually, I'm not. We did address, though, the issue of the mold in our letter of June 5th directly to Mr. Fox, and we advised him that the mold was found, remediated, and was resolved. So I'm not sure why they're bringing it back up again.
Yeah, at the June 28th board meeting, I believe they used the term toxic mold approximately 15 times in the meeting. 15 times. So, I mean, who's counting? Let's see. I have to ask, because Walkowitz sent the letter to Cam Patton. The only reason I found out about it was through the website that the district uses for information, known as the Weebly page. Cam Patton never redirected Mr. Walkowitz to the school or shared the letter with MCA. In your opinion, is that a violation of the MSA?
It certainly could be. Again, the whole concept behind the MSA was to try to resolve differences and work out a process where those differences could be resolved. For them to receive that kind of information and not give that back to the school, it violates the spirit of that. And I believe it was done probably intentionally. And then to put it in this letter as the last point that they're making of all the issues that they've raised before, to come out and say, well, we're concerned about student safety and all that stuff, without ever having given us that information, it's very disingenuous at best.
My question next is for Mr. Hall. Before John raised these statements, as we went through just now, did he or any of his staff contact you or any staff members at the school to confirm the validity of these accusations?
No, in fact, we'd welcome that kind of thing. If they would come and talk to us directly, we welcome it. They're depending on other people giving them information. It's confusing them. It's misleading. It's deceitful. And a lot of this stuff is outright lies, and it should stop. They should come here. We welcome them to come and talk with us anytime.
Thank you. All right, so Mr. Wood, based on the responses to every point made in this letter today, MCA was put on a fake probation for no reason other than to publicly defame and damage MCA. Would you agree with that statement?
I would agree that this letter, while not addressing the points that we made in our prior letters, is not only a violation of MCA's rights, but also could be interpreted as a breach of our charter agreement. I would.
Concerning alleged violations of state or federal law, decisions in these areas are not adjudicated by bureaucrats or their attorneys. These decisions are constitutionally decided by the judiciary. Is that an accurate statement?
At the end, if there's a attempted to terminate MCA, we have as I've said at our board meetings, we have a remedy. It's available to us in Florida statutes to ask that the Department of Administrative Hearings hears the facts in the case to set aside that termination. There's also a potential, because they put us on this quote-unquote probation, that is a unadopted rule that they're trying to impose upon the school. So there's a remedy there. But at the end of the day, you're 100% right. Bureaucrats that are in positions in these agencies aren't the ones that make the ultimate decisions. That's why we have courts.
So here's my concern. Fishbane's client is the CCPS board, and they have the authority to terminate MCA. Is that correct? They're the sole
They do.
authority, right?
Yes.
Okay. So it appears that Fishbane and Fox have been lying to the CCPS board and not disclosing the letter sent by MCA's counsel to the board members. As an attorney, are you required to provide your client with material information?
Yeah, ethically, you are required to provide your client with information regarding the facts and circumstances of every matter that you are handling. Of course, none of us here today have been privy to those communications between Mr. Fox and Mr. Fishbane, nor Mr. Fishbane and any one of the board members that he represents.
Well, Stephanie Lucarelli, board chair, came on the record and asked if there were any responses. That leads me to believe she's unaware of the responses. So, and when Fishbane tells her that there were only 2, so I've done a public records request to get those communications to see if in fact they were being sent to the board members. But I feel like we're in this position yet again. You see they go down the same track of removing me, Ms. Malinerich, Mr. Hull, get them out of there. It's all in this letter again. More defamation, more reckless statements made by these attorneys and the board members. And at the end of the day, we've been doing this now for 2 straight years. Mediation was an absolute joke because 6 days after the settlement agreement, they were already drafting their first attack letter against us. So they've made all these claims, and people out there in the public are saying that this board is irresponsible, we're not following the laws, and this is damaging to not only the school's reputation, but us as individuals and our jobs, our careers. And in this latest fake probation, I feel like we can't continue this, and I'm asking what your recommendation is. And I mean, we did file a declaratory action with them, and we obviously got what we wanted in the end. I mean, is this a situation where we need to let the judiciary decide? Because really, if they want to go for termination, which Jen Mitchell brought up twice at the July 28th meeting about terminating us, they have to have clear and convincing evidence. Ladies and gentlemen, I have clear and convincing evidence of a conspiracy against the school. We just went through this entire letter. There's no evidence. In fact, it shows that they've been lying. So what do you recommend we do at this point? Because we cannot keep spending money on letter writing campaigns going back and forth, because that's obviously not working.
Yeah, I would agree with you, Board Chair, that the correspondence and requests to meet have been ignored, and it's not a strategy that seems to be working at all. Which leads us to 2 alternatives. One, try to go over their head to the FDOE to get them to stop, or 2, take advantage of several court filings that could be made, which we'd like to get the research done and submit that to the board, so the board can consider not only whether that's an avenue they want to follow, but also to understand better what the consequences of following that action would be, both good and bad.
I mean, Mr. Wood, we've been taking hits left and right for actually more than that. And, it's time to put them in their place for what they've done and the damage that they've caused. I mean, look at how much time we've just had to spend in our board meeting on this nonsense. I mean, how much time has been taken away from the most important thing here and what we do? And think of where we would be as a school had they not done what they did. And now we have clear and convincing evidence of a real conspiracy that involved Hillsdale, Erica Donalds, Matt Mathias, FDOE was even involved. So it's hard to even, when you mention bringing them into the mix, well, they could be considered a co-conspirator as well, and that concerns me.
I would also like to say that there are a lot of lives that are affected by this continued hoax and these attacks on this academy. There are lives of faculty members and potential faculty members who have their families to think about. There are students whose lives are affected dramatically by this kind of hoax being continued to be thrown at us. There are financial repercussions that I can't even begin to outline, from not only just legal fees, but also how it affects the school as a whole, with our reputation being attacked constantly. I'd really like to know from our legal team what we can do to put a stop to this, because it is so obviously now just deliberately untrue to take advantage and take hits against a school who started out at a financial disadvantage, and then they continue to hit us and continue to hit us and continue to hit us, and then for us to be criticized for defending this school with dollars that we have very few of to begin with. I mean, it's just ludicrous, and it's time for us to get some advice about how to put it to an end. We've been working in good faith for a very long time, trying to get these issues resolved so we can move forward and do the best thing for these children. What's next?
Can I just step in? You said we've acted in good faith. We complied with everything in the MSA. We had the independent audit confirmed that we did everything that we said we would do. And they move the goalposts every time. And it's like, so, and here's another question I have, speaking of the MSA. I mean, we now have documentation. And in fact, Mr. Steer, I'm gonna have you pull it up. First of all, the mediation confidentiality agreement, if you can open that document. I just want to point this out for the public. This was signed on August 1st. As you can see, if you scroll down, there's my signature, the superintendent's signature, Judith Delgado, Peggy Ani, Ruben Dupay from the Coleman firm, Sean Arnold, John Fishbane, Jim Fox. All of the signatures are here, and it's crystal clear about the privilege of what is said in mediation. And what's interesting, if you also pull up the, sorry, I just want to make sure. There's the Hillsdale confidentiality JPEG. I don't know if that one will open. It's a screenshot of an email. I'll read it to you. There it is. August 1st, 2019 at 11:18 a.m. That was during mediation, during. And this is from Larry Arnn, president of Hillsdale College, secretary Madison Moore to Larry Arnn. And it says, sir, Bob, and Bob is Bob Norton, Hillsdale's district general, or not district, general counsel. It says, Bob asked me to pass this along. Bob has had some communication with the lawyers regarding the MCA mediation. Kelly and the board's opening position is to say that they have no use for Hillsdale and that Hillsdale hasn't been much help. Wow. So, Mr. Arnold, with that said, and I also have another email, it's an email exchange between Matt Mathias and Jacob Oliva. If you pull that one up, I think it's on like page 9. Scroll down. He says, this is Jacob Oliva is the chancellor at FDOE and was present at mediation, I believe signed the confidentiality. So Matt Mathias says, it is my understanding, keep going. There it is. The first paragraph, it is my understanding at the mediation between MCA and CCPS, it was agreed, though not written in the mediation settlement agreement, Hillsdale College would continue to be the education partner of MCA consistent with the charter application. Then you go down to the fourth paragraph. It is also my understanding there may have been a particular individual in mind to join the MCA board of directors, although not specifically written in the mediation settlement agreement. So I don't know about you, but this looks to me like he's getting information that was supposed to be confidential. So with that said, Mr. Wood, how do we get this mediation settlement agreement thrown out? And the fact that they obviously were violating the confidentiality during and after.
Again, since we didn't represent the school for that mediation, I'm not sure what potential issues there are with the confidentiality of that mediation. Obviously, as a school, a public school, that information, if requested, would have to be disclosed. There's a lot of case law out there about having agreements that with public entities that those agreements become public knowledge. They must be disclosed. So I'd have to look at that issue.
And I don't mean to.
There's other reasons to throw out the MSA that have nothing to do with the breach of confidentiality.
No, it's also a breach of the MSA. They've breached it numerous times, item number 10 specifically, because
Right.
if you go to, and I can pull these up, the Retzel invoices, Mr. Steer, we can start with August and then go on to September, October, November, December. It's one parent meeting after the next that they were never redirected to the school. We weren't even aware of it until we got these public records. And you can see it in here. Meeting, conference with parent, met with concerned parent on 8/8. I mean, he can pull up every single one of these and you'll see that they were doing this. So, and back to the confidentiality, what they specifically told us that would become public record was the MSA. And that was it, as far as what became public, but anything discussed in mediation could not be disclosed outside of those rooms. So,
And that's true of all mediations. The reality is that it would have a chilling effect on the exchanges during the mediation process if everything that was said during that mediation would become public knowledge. That's why they have that statute that says, anything that's discussed in mediation is inadmissible in any court. So,
well, and just so you know, they had asked if Hillsdale could be a party to the mediation, and we declined because they were not a party to the mediation, so they did not sign the confidentiality. But the fact that you have CCPS attorneys contacting Hillsdale's attorney during mediation is extremely troubling, and I think the Florida Bar will agree to that as well. So, all right, so we're gonna, I think if there's no other questions, where we're leaving this is you're gonna do a little bit more research to find out what we can do to go on some serious offense against this, these lies, defamation, and the constant attacks that won't stop. And I don't know if Mr. Fishbane needs someone to check, his cognitive abilities right now, because how is it that you can send this many letters and clear the record and there's just complete denial and just continue lies? I don't get that. So you're gonna research and you're also gonna look into this, getting rid of this MSA, is that correct?
that's correct. We'll have a report to you within the next week, and then we'll go from there.
All right. Any other questions for Mr. Wood before he signs off? Okay. All right, Mr. Wood, thank you so much for being here today. We really appreciate it.
Thank you, and I feel really bad that the board have to go through this. It's unfortunate. Just hang in there.
All right. Thanks so much. All right. Well, that was productive. All right, we're going to go on to the executive director report.
Things are going very well here with Mason Classical Academy. The school's getting ready to begin its 7th year of operation. The current pandemic has certainly shaped our events over the past 6 months, as has the continued hostility among a small group of disgruntled people. The last CCPS board meeting served once again to exacerbate the hostility, which is most unfortunate and unnecessary. It must be stated for the record that what John Fishbane did to Mason Classical Academy during their last board meeting is not only unethical and immoral, but it's also factually inaccurate. I've made it a point to take Mr. Fishbane's continued attacks for what they are, unethical, immoral, and inaccurate. I've chosen to remain silent and continue working for MCA to the best of my ability, in spite of all these attacks. Unfortunately, his latest round of outright lies went too far. It's my sincere hope that these actions stop immediately, and that the CCPS board members are informed immediately that what they're being told by Mr. Fishbane is simply not true. They need to be told this somehow, because if he's the filter getting them the information, they're acting on false information. If the CCPS Board of Directors continue taking action against MCA based on Fishbane's false and misleading allegations, then they will be just as responsible for spreading the misinformation as he is, for the unnecessary damage to a good school as he is, for the financial burden placed upon the school as he is, for the ethical dilemma in which he now finds himself. This all needs to stop. It's unnecessary and it is wrong. Other people who are involved behind the scenes, they know they should stop too. They can help put an end to this. To Roy Terry, Stephanie Lucarelli, Jory Rustberry, Eric Carter, Jen Mitchell, and Dr. Patton, you are all more than welcome to come to Mason Classical Academy and see things for yourselves. They've always been welcome. Mr. Terry and Mr. Carter actually did accept my invitation a few years ago, and we had nice discussions. They know me, and they know what's being said about me in the school is not true. They know this. They have to know this. So I make another invitation to them. Let's talk. MCA is made up of good teachers, leaders, and families. Those of us working on behalf of the MCA families will continue to do the best we can, but it should be made known that Mr. Fishbane is way out of line, and that the MCA community and Collier County Public Schools deserve far better than the garbage he continues to dish out. That said, I'm happy to help correct the record here today and report that MCA is not only in a position to open on time, but it's in a position to open strong and ready to deliver a high-quality classical education to any parent who chooses to come and partake in what we have to offer. So first, the MCA reopening plan has been approved by CCPS. Special thanks goes out to Mrs. Smith, Ms. Mirabali, Ms. Westervelt, and Principal DeMasi. This was a large and complicated task, and it was handled with professionalism and speed. The board should be very proud of them. I'm also happy to report that the cordial relationship and positive relationship is being developed between Principal DeMasi and the district charter school representative, Dr. Sharman Curtin. We look forward to working with Dr. Curtin and her team and are happy to have a positive relationship with them heading into the 2021 school year. Mr. DeMasi is also looking forward to his job as principal with dealing with curriculum, instruction, teachers, students, and parents. That's his job. He knows MCA, he loves MCA, and MCA is thankful to have his leadership. So on that note, we're going to have a Meet the Principal event on Monday, August 24th, and we encourage all families to attend. You ready, Principal DeMasi? Good stuff. Next, Governor DeSantis recently put forward an order for all schools to have panic systems installed, right? We are already ahead of the game there. We're happy to report that MCA already has such a system in place and that we're going to expand it even further. So that one's done, and we're going to expand on that. Next, the MCA supply program for students has roughly $24,000 donated from its parent base and our families. We sincerely appreciate that. Thanks to everybody who donated to that program. This program allows for students to have their own individual supplies. So this is especially helpful during a pandemic. I think we were ahead of the game on that one also, but it's already in place. Students have their own supplies, and that's helpful to our health and safety in the school. It also saves parents from having to run from store to store picking up supplies, another positive during a pandemic. So we thank all these parents for the continued support, positivity at MCA. The latest enrollment report from our registrar shows that we have over 940 students enrolled at MCA currently, and we have over 330 students on the MCA wait list. Now, we do expect that more people are going to pull out of the school because of the pandemic and our lack of online option, but we also expect more people to sign up for those same reasons. So there's a lot of uncertainty out there, there's a lot of fear, there's a lot of unknown. So we also thank our families for their support and patience and understanding throughout this whole process. It's been tough on everybody. Next, there's been talk by John Fishbane about a number of items being late or having problems. I really appreciate the board getting with the attorney and calling him out for these things and putting it on record that this stuff just is not true. So I strongly recommend that the CCPS board members be informed themselves. They need to be informed somehow that he's not giving them accurate information. And they're basing their decisions and comments on false information from him and others. So, for examples, our threat assessment has been approved by the FDOE. We have a letter from them about that. Our Form 990 is not out of compliance. Our fire inspections are all up to date, as they always are, and there were no discrepancies found just as of last month. There is, in fact, an executive director position at MCA. The position was there in the early years of the school, and it is clearly still there now, as shown in the modified charter application approved this summer by the Collier County Public School Board. Again, I recommend and request that CCPS board members come talk directly with us rather than relying and acting on false information, and report it to them by their counsel and other people who they are meeting with behind the scenes, if that's happening. On that note, I recommend the MCA board members ask their own counsel what the law is pertaining to a lawyer withholding information from their client, which you did, and I appreciate that, and I do look forward to that answer. I can't imagine what it would be like if your counsel was not informing you accurately, what your decisions would look like if you were being misinformed and misled. Next, the mold situation. We've already addressed. It is 100% contained, remediated, and under control. As soon as it was identified, the school and the board attacked the problem, remediated every bit of it, and painting is to begin today. So there is not a concern there specifically to Mr. Carter for bringing that up so many times in your comments. Please come by. Come on by. We're here to talk, Mr. Carter. Any drywall that's been removed has been replaced, spackled, and sanded. Any trace of mold has been eliminated by highly qualified professionals. I truly look forward to the day when all the hostility toward MCA comes to an end. It should not be about personalities. It should be about a school. It should be about students. It should be about curriculum and instruction. It should be about a choice of school where you can come here and get something that's not offered by the district or, frankly, across the nation. That's what we're here for. And we've delivered on that year after year. We can't be all things to all people. Sometimes people need to be told no. If they don't get their way, it doesn't mean their concerns were not addressed. It means that it just didn't happen in their favor. And we have a mission to deliver with this school. We promised a certain thing, and we've always delivered on that promise. The personalities should just stop. This should not be about personalities. The school has earned A rating since its first year and is among the top 2% of all Florida public schools. I hope that this report and any other reports by the MCA Board of Directors and their council demonstrates the school's compliance with the sponsor's wishes and that everyone can move on in the best interest of the students and families of MCA. Thank you.
Thank you, Executive Director, Mr. Hall. Board members, are there any questions or comments for him after that report?
No, other than just, thank you for all the details, and I concur with thanking everyone staff that assisted all of these projects during the summer. Really appreciate it.
And thank you for keeping us informed, the board. I feel like we know what's going on. We know how hard you guys are all working. It seemed like last year I felt like we were kind of in the dark about a lot of things as a board, which we weren't accustomed to. So it's really been refreshing and nice to know what's going on. And so thank you, staff, for all your hard work.
I'd just like to thank you for your report to Executive Director Hall. I think it was very well stated. I just wanted to say that I feel that the misinformation, the misconstruing or failure to see truth throughout this entire ordeal over these years has been intentional for the profit of certain individuals. That this misinformation is being disseminated, is being spread by those who stand to profit from the misinformation and from our damage, the damage to this school. And they're hoping to eliminate the leadership of this school. And I hope that we can get to the point where the interest of the Collier County Public School Board is actually in improving the conditions and education of the children of Collier County, because I cannot understand their lack of curiosity about what we're doing at the #1 elementary, middle, and high school in Collier County, why their focus is on tearing us down and not seeing what we're doing here, what our faculty and our leadership are doing to improve the conditions and education and lives of children in Collier County? Why is their focus on tearing us down and not on trying to spread that good to all children in this county?
Thank you. All right, we are going to go to community comments. Thank you for your patience. We are going to go with Mrs. Greer, please, and you have 3 minutes.
Good morning, board. As a parent who's been at MCA since it's opened, I am so glad this board has stood up to CCPS and others that have tried to take Mason Classical. Many people have continued to bring documents to light of this long-time plan. And as it keeps happening, the district keeps lying. I want to see this school file bar complaints against Mr. Fishbane and Mr. Fox, as well as ethics complaints for both attorneys and the Collier County School Board members. CCPS board members have ignored the documents and evidence of the collusion and plan of Mr. Fishbane, Hillsdale, Joe Baird, Matt Mathias, Erica Donalds, and many others. By ignoring information and the records that have been found, that brings this school board into the collusion of this plan. Yes, they have ignored it because I've personally sent them records. There's no doubt. I have documentation. CCPS board have been misusing their position in an attempt to benefit someone else, which is a violation of Florida ethics. I've researched that too. Board filing these complaints is not easy. Trust me, it takes plenty of reading and time. I'm not a law student, but it must be done.
Thank you. All right, the next community comment is Mr. Kelly.
Good morning, Jim Kelly, longtime resident of Collier County. Been a parent since before the founding, and once I heard Hillsdale was involved, I jumped on, sight unseen, and believed in the mission because I believe in Hillsdale. I still believe Hillsdale is a great organization when it comes to educating young people, college students and children as well. They've got great curriculum online. They've got lectures online. I've received in-premise before in-premise got over about 200,000 or 300,000. Anyway, 1993, I think, is 93. Bottom line is what I see as a parent is I see conflict between one board and another board, and it's being mediated by lawyers. It would be a beautiful thing. I don't know that it's possible for board members here and board members there to go face to face and have an open meeting and talk about what's going on. Now, I realize that's probably not possible, but I believe in my heart that if those 5 members saw the truth, they would not be saying the things they're saying, asking the questions they're asking, and voting the way they're voting over at CCPS. It makes no sense. Dennis Prager's a guy I love to quote, and he says, if a study doesn't comport with common sense, then it's probably wrong. As a parent, it makes no sense to me that CCPS says what they say through a lawyer and an outside attorney in a public meeting, and you do what you just did, point by point, thoroughly answer every question they have. And most of those questions are not specific to a law, a bylaw, a policy, or whatever. It's just whatever Mr. Fishbane decided to put in his letter, his feeling. Okay, we don't deal in feeling at your level. You deal in black and white. You've got procedures, and you got to follow them. And as far as I was concerned, once you guys went through the mediation process, you answered the letter. I read what you answered to the board, and I don't understand why they think you didn't do what you were supposed to do. You did it, as far as you said, and it hasn't been thoroughly challenged properly, as I can tell, because they didn't go point by point. They just went by feeling. So it makes no sense to me as a parent. So there's some disconnect here. And when it gets to the whole concept of politics, I've said it to the Collier County School Board, I've said it to CCPS, and I'll look at you and I'll tell you what I told them. I said they are the pointy end of the spear of the tyranny of leftism in America. They're interested in big government, big solutions. They care nothing for the kids or the parents. Now, I can't say that to you. I'll say just the opposite. Thank you for standing up, because it is tyranny, okay? You're doing a good job. I applaud you for everything. And the number one issue that completely defines it for me is the performance of the kids in this school. As you pointed out, academically, they're doing very, very well. So once again, it makes no sense for a school board to attack maliciously, publicly, the way they have attacked this school, when the kids are being educated to a point that is, well, let's just say above average. But it's not, it's superior. You guys are doing a great job. Thank you for your time.
Thank you. All right, we are going to go on to the approval of submitting bar complaint against James Fox and John Fishbane subsequent to board review and discussion. Mr. Steer, if you could pull up, there's a Word document, Florida Bar Ethics. It's a Word document. All right, I will begin reading it, a couple things in here about attorney misconduct. A lawyer shall not. And item C says engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Then it goes on, Rule 4-8.3, reporting professional misconduct. It says reporting misconduct of other, there it is, of other lawyers. A lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects must inform the appropriate professional authority. I added this item in light of all of the overwhelming evidence that both John Fishbane and Jim Fox have portrayed over the last, especially the last year. You know, we have the attorney letters. I've got all these stacked here. You know, in fact, let's do a comparison. If we can pull up, I want to get the very first August 14th. It says Retzel 8/14/19 letter. I want to show this. And just let's kind of scroll through to the first heading. Okay, there it is. Sunshine Law and Agenda violations, and then they make their accusations, and if you keep going, then they go, and there's another heading, board and staff professionalism and civility, and then they make their accusations here, and as they keep going, actually, I do want to point something out. If you go back to the Sunshine Law and Agenda violations, I just think this is really important. They first began, like I said, 6 days after the mediation settlement agreement was approved. They tried to say that because our board did not post the MSA as an agenda attachment, we were in violation of the MSA. But when Coleman responded, he specifically says, well, the MSA is not even a binding document until both boards vote on it. So there was no violation. Anyway, but back to the other thing I also want to point out in that Sunshine Law, if you look at the second sentence, it starts off with speakers would be given the opportunity to speak prior to action and non-action items being presented so that the board can consider public input prior to decision-making or informational item discussion. Notice informational item discussions. If you all recall, at the June 9th, 2020 CCPS board meeting, they denied our community to speak on the informational item, and in fact, 42 comments were submitted for that informational item. So here they're holding us to a standard, which we have always complied with. Okay, here it is, saying here's, you know, we've never not done that, but yet they're allowed to do it. And who holds them accountable? They don't have some Weebly page calling them out for every little thing that they might have possibly maybe done wrong or didn't do wrong or whatever. And here it is, they did not, you know, they didn't even comply with the actual law. They blocked the public. All right, so let's continue because I just want to show the headings here. Okay, we got the civility, flawed grievance policy heading. They make their false accusations, attempts to stack the board, more false accusations, lack of principal and teaching staff, rejecting its contract with Hillsdale College, and so on. All right, if Mr. Steer, if you could pull up the Coleman response to 814 letter, because this goes to Fishbane's accusation that we've never responded to any of the accusations. So I want to show you, this is Mr. Coleman's response, and it's actually really fantastic, and it's an attachment. I think it should be on today's agenda. If not, we'll make sure it gets on there, but they've been shared. Let's scroll through this one, because it's very interesting if you compare it to the one we just saw. So we'll scroll to the very first heading. Oh, there it is, sunshine law and agenda violations. Huh. So here Michael Coleman addresses the issue. Let's go on to the next heading. And it's board and staff professionalism. Same heading that was in the previous letter. Flawed grievance policy. I mean, this all attempts to stack the board. All explaining with the facts, not feelings, facts. And he corrects the record. Coleman does a fabulous job. I'm telling you, it's a solid letter. Lack of principal and teaching staff. It's all here. Rejecting its contract with Hillsdale. And this is no different, and I don't need Mr. Steer, I appreciate you pulling these up. It's no different than the September letters, identical. Then you go to what Mr. Wood references, that June 5th letter. The June 5th letter is phenomenal. It's like 16 pages, like clearing up the record, completely ignored. So with that evidence, you also have, I mentioned earlier with Mr. Wood on the phone, the violation of the confidentiality of mediation. You also have the original Fishbane report from June 3rd, 2019, an unredacted version of that, which I'll speak on. It has Mr. Hall's son's name in that document. It was sent to other counties by the district. He did not give permission. So they accused us of all these FERPA violations, and here they're the ones doing it. So everything they accuse us of doing, they're the ones actually doing it.
And that's a federal offense.
Yeah. So the other one, okay, here's another document I'll have you pull up.
I'm sorry, if I can say one thing about that. My son is very upset about that too. He's going in his third year of college at Washington University, and that kind of thing, that can affect him. And when he found out about it, he's not happy. He's looking into the matter himself also. A clear FERPA violation. John Fishbane outed a student, not only a student, but my son, and he did not have permission to do that. So the very thing they're accusing me of, or the school of, they're doing themselves, at least in terms of John Fishbane. So for the record.
Thank you. If you could pull up private meeting recorded document. This is an email exchange between Jim Fox and John Fishbane, and if you look at attachment at the top of the page, it shows August 5th private parent meeting. So obviously it's private. It was an illegal recording, and you've got two attorneys sharing an illegal recording. Here it is. So I just want to point out that documentation. So between the blatant lies, confidentiality agreement for mediation violated, the trafficking and using an illegal recording, which they used it in the April letter against us, against the school. And then I want to point out, because you kind of brought it up a second ago, or a little bit ago, about what Jim Fox said. And I have the actual quote. And this is where it's like, wait a second. If what you say is true, then how are you guys missing this? Here's what Jim Fox said at the June 9th, 2020 CCPS board meeting. Number one, the facts. They claimed that our entire analysis was based on a third-party website, Weebly. False. Demonstrably false. Number one, this website has only appeared in the last couple of months. Number two, we have reviewed every single board meeting, every single committee meeting, the videos. We have kept track of the exact words that were used. We have examined every document provided by Mason Classical Academy. We have examined when they put things up on the agenda and when they didn't. There is absolutely no basis, no truth to claim that this is based on some sort of third-party webpage. How they get off on making those kind of claims, I couldn't even begin to understand. And if this were not so serious, I would tell you that this is just a bad joke. Well, for someone who has paid that close attention and watched every word, Number one, the Weebly page was created in March 2019 and posts began about MCA began in June 2019, not what he said. So his statement was a lie. Two, according to Fox's invoices that he sends to CCPS, he has been meeting with hostile parents since July 2019, which in July it was an MSA violation, but after that it was clear violation of the mediation settlement agreement. And then when he says it's just ridiculous that we would, claim that they were using the Weebly page, in the May letter from Fox, there are 7 footnote references to the Weebly page. 7. So, just complete lies. So anyway, I'm gonna stop there, but this is why I strongly believe as a board, based on these items, we should, as a board, file it.
When you're finished, if I could ask a question too.
That email again, where they were, the Fox and Fishbane were trafficking in a illegal recording. You note that at the top, this is from Leanne Zinser, so this is a public records request. All public records requests are cleared by John Fishbane before they're released. Notice how these names are redacted. These are not minors. They just decided to redact names. Yep.
I would ask also, maybe our attorney could chime in on if it's a violation, if they're watching these videos and there's only one source of the videos, one camera at these board meetings, if it's by a parent, is that a violation of the mediation settlement agreement, right? So there's only one way he's getting these videos, and so is that a violation of number 10 also, where he's working with those parents? Something to think about, something maybe to ask our lawyer about.
Well, I just think this all goes to the reasons why a bar complaint needs to be filed against them. I mean, it's clear. The dishonesty alone, it's just unethical, and the attacks we've had to endure as a result, it's been reckless, so.
And I was wondering, could you find the December letter from Jim Fox, please? Sorry. Okay, great. All right, so this is the December 16th letter from Jim Fox to the school, and he closes it with, here we go. He talks about, there's chronic disregard for the consequences of our actions of not supposedly responding to their undocumented accusations. In the last sentence, it says, we are therefore constrained to advise our client, so we being his law firm, to advise his client, Collier County Public Schools, and the Collier County School Board, our client, that under these conditions, any further contractual relationship with MCA is untenable. Now, how on earth an outside counsel for Collier County Public Schools can say that I'm going to advise Collier County Public Schools that your contractual relationship to operate Mason Classical Academy is untenable and that it should be severed is, I think, just beyond the pale, ethically, legally, you name it.
I do want to point out another egregious lie, as we've, received a lot of public records requests, subpoena documents. In the the September 4th Fox letter, he says John Fishbane had very limited contact with Hillsdale during the course of the investigation. So now when the records are coming forward and being provided, it shows that they had a secret meeting planned as early as October of 2018. They met in November 2018. We were unaware of it. The only person who was aware of it, according to the document, is Erica Donalds, who was a sitting school board member at the time. And then there were multiple emails between the executive director of the Barney Charter Initiative at Hillsdale and John Fishbane from January 2019 through the summer. So for Fox to write this, they had very limited contact with Hillsdale during the course of the investigation.
If I could make a comment about that, I mean, one way they might be doing it is through collusion with certain people, maybe some current parents or former parents, relaying information. And on that note, I wonder, do you think things like that are going to come out in the trial with Joe Baird, where it's going to be found out who's been supplying information, running certain websites, things like that?
Well, that's a great question, and I know with this judge decision, as far as this case moving forward and why it's so good for the school, not only because of the attorney's fees, but that these subpoenas will be sent out to multiple parties that we believe are involved in all of this. So I do think we're going to get to the bottom of a lot, so they will be sent out shortly.
I really look forward to the truth being brought to light. Thank you.
We do too. Thank you. Board members, is there any other discussion? Otherwise, I think, there should be a motion to approve filing a bar complaint on behalf of the MCA board.
I'd just like to clarify, so are these two separate bar complaints, one against Fox and one against Fishbane?
That's correct.
Okay.
Yep, they'd have to be separate.
And would we need to bring it up at another board meeting, a discussion of whether or not the board would want to consider an ethics complaint against each individual board member for being complicit in these lies?
You could potentially make it a separate motion. I mean,
But since it wasn't on the agenda,
Yeah.
would it be better to bring
Yeah,
it back at
we
the
can
next
bring it
meeting?
back. Mhm.
And then I also am wondering if you could, on behalf of the board, request some advice from council. I'm wondering if we could find out what legal remedy those 42 citizens of Collier County would have who were denied their rights at that June 9th meeting. I don't know if that would be an ethics complaint against the board as a whole, or a bar complaint against the attorney overseeing the meeting.
I think it might be easy just to add it as part of the bar complaint, that they were denied their, he talks a lot about First Amendment rights, and 41 people were denied theirs.
I'm sure that'll be part of our bar complaint, but I wonder if those individual citizens also have the right to file a complaint. And if they need any advice, I'm sure that we welcome the inquiry.
Yeah, in fact, Mr. Steer, there's a bar complaint form in the folder as well, if you want to pull that one up, just so the public can see what this looks like. There are multiple parts to it, and this can be found on the Florida Bar's website, so anybody can file a bar complaint. I do know that there is a bar complaint against both Fox and Fishbane at this time from a citizen that's going through the process. So, yeah, I think, but this gives you all the instructions of how it will be done. And do you recall when our board voted and filed that complaint against CCPS with FDOE? We had approved that. I think the important part of that, even though the FDOE sent it back to the district, is that there is a paper trail that FDOE cannot deny that they were unaware of what was going on. And I think it's clear that the Florida Bar, they need to be aware of what's going on here. Because who's going to hold him accountable? Kamala Patton's not, the school board's not, but the Florida Bar will. What's that? FDOE's not either. No.
I'm sure it'll be exposed in an NDN piece soon.
Is there a motion to approve?
I'd like to add the consideration of possibly adding another attorney to this bar complaint, and that specifically is Sharon Arnold with the Arnold Law Firm. And I just want to point out a couple documents to you for that consideration. At the July 2019, I'll call it the termination meeting with the school district, Braxton Paget, who is counsel with the Arnold Law Firm, during his public comment, he was talking about the offer from John Fishbane sent to us, think it was on the 9th of July, on how we were going to essentially avoid the termination that was going to take place on July 11th. And with that, he said, in this context, Mr. Fishbane proposed that Hillsdale College be able to essentially come in and take over Mason Classical Academy. And then he went on further in his comments and said, I implore you to look outside the district where a private college has taken over a charter school. You are not going to find it anywhere. So essentially what Braxton Paget was saying, that this is, you know, beyond the pale, saying, okay, we called this termination meeting because you haven't done what Mr. Fishbane requested in his part of his Fishbane report. So in order to avoid that termination, you're gonna have to turn the entire school over to Hillsdale College. And now through discovery, we received, or we were informed from an email on July 30th at 2019, which is 2 days before mediation was going to take place, right? And so this email is from Larry Arnn, president of Hillsdale College, to Michael Bilecka, good friend of Erica Donald's and her Optima Foundation, which is Hillsdale College affiliated. So this is to Larry Arnn, July 30th, 2019, to Michael Bilecka. I learned after our call that Sharon Arnold, lawyer for the school, called our general counsel today to propose that, and that again is Bob Norton, right? To propose that, one, you be the chair of Mason Classical Academy, so Michael Bilecka be the chair. And then we, Hillsdale College, appoint or approve 1 or 2 additional board members, and that we, Hillsdale College, remain involved. So we have our attorney representing the school 2 days before mediation, offering up board chair and then also 2 additional board members to Hillsdale College, and that they remain affiliated with Mason Classical Academy. So it was, from what I understand, and we talked about this at a board meeting, I think in December, Mr. Arnold told you at one point that he represented the Optima Foundation and Erica Donald's, correct? And this was never disclosed to the board, as far as I remember, correct?
And to that point, typically attorneys are required to put in writing that there could potentially be a conflict, and he did not provide that.
Yeah, absolutely. I mean, attorneys, it is a very big deal with attorneys. If there's any potential conflict, they have to put it in writing, just so the existing client can make the decision to either, okay, I understand you disclosed this to me, I still want to remain, still have you as counsel, or seek other counsel. That's the full legal purpose of a disclosure. None of it was taking place, and our own counsel was offering up board chair and board members to Hillsdale College to essentially take us over. And then, oh, by chance, he also represents the Optima Foundation, and now Naples Classical Academy. And that if the Optima Foundation, if Hillsdale had a board majority, they would, I would assume, hire Optima for the management of Mason Classical Academy, and the Optima Foundation would profit to the tune of around $800,000. So, with that, I think the motion to file a bar complaint, I feel, should include Jim Fox, John Fishbane, and Sean Arnold.
Mr. Bulduk, I don't disagree with that assessment and with that idea. I'm just wondering, now that subpoenas are being served, I'm wondering if we should wait another week or so to see what other evidence comes up that might be important considerations for the bar, and if we should wait until we have more evidence potentially to file that particular complaint. I don't know, or would we just do a separate one if more comes to light through depositions?
Yeah, that makes sense to me. You know, why rush it? You know, yeah, for him, and you know, wait and see what comes out, which, you know, could add on to it, could make the complaint even stronger. So yeah, I agree. That sounds good.
I do feel, though, there's plenty on Fox and Fishbane, so is there a motion to approve our complaint?
Who will be drafting that complaint, and will the board have a chance to review it before it's actually submitted to the bar?
Yeah, I was willing to start the draft, have it reviewed by council, and bring it and share it with all of you as well, for the record. So that should be reflected in the minutes, that we'll share that via email while we're in the process of drafting it. But yeah, it would be reviewed by council as well.
Great, all right, thank you. So, the motion then is to authorize the chair to draft a bar complaint, 2 bar complaints, one against John Fishbane and one against Jim Fox, for ethical and legal violations of their obligations as lawyers.
Yeah, I would phrase it as that I, on behalf of Mason Classical Academy, will draft the bar complaint with input from the board and council, 2 separate complaints. They have to, the motion needs to read that it's going to be 2 separate, because
Should it be 2 separate motions, or?
No, it could just be one, but that they're 2 separate complaints for dishonesty, fraud, deceit, and misrepresentation.
All right, I so move.
Okay. All right, is there a second?
Second.
There's a motion to approve sending a bar complaint to the Florida Bar against both John Fishbane and Jim Fox respectively for dishonesty, fraud, deceit, misrepresentation on behalf of MCA. All those in favor state so by saying aye. Aye. Opposed? Passes unanimously. Okay, now we're going to go on to the updated academic calendar, which was uploaded. Ms. Westervelt, I don't know if you want to speak on it, or Mr. Hall, or anybody. Ms. Demansky.
And in doing so, we still have 175 days, and Collier County Public Schools did approve our calendar.
Okay. Is there a motion to approve the updated calendar?
I vote to approve the 2021 calendar.
There's a motion. Is there a second?
Second.
Any questions, discussion on this item? All right, all those in favor, state so by saying aye. Aye. Opposed? Passes unanimously. All right, we got policy updates, policy manual update. Ms. Westervelt, if you just want to give a brief introduction to this agenda item.
Yes. Some of the things that we looked at were policies that could be redacted because we don't have anymore, policies that just needed to be updated, with different wording of executive director or principal in the appropriate places as per their job descriptions. And we just tidied it up and cleaned it up.
Yeah, you guys did a great job. Thank you so much on that. Is there a motion to approve the updated policy manual?
I move to approve the updated policy manual.
Is there a second? All right, any discussion, questions for staff? Okay, all those in favor of the updated policy manual state so by saying aye. Aye. Opposed? Passes unanimously. Same thing with the MCA handbook, Ms. Westervelt?
Yes, there was just a few changes. Things like Land's End, Sears stores don't exist. It's not kid care, it's healthy kids. Our new Principal DeMasi, and our new board member, Natalie Epperson. So those were the only updates in there.
Okay. Is there a motion to approve the updated MCA handbook? Okay, second. Is there there a second?
I second.
All right, all those in favor state so by saying aye. Aye. Opposed? Passes unanimously. Student Code of Conduct, Ms. Westervelt?
Yes, the student code of conduct remained the same. The only change was, again, being able to try on the uniforms at the Land's End Sears locations.
Okay. All right. Thanks for cleaning that Code of Conduct up. Is there a motion to approve the updated Student Code of Conduct?
Motion to approve the updated Student Code of Conduct.
Is there a second? All right, all those in favor of the updated Student Code of Conduct state so by saying aye. Aye. Opposed? Passes unanimously. Finally, the Student Progression Plan, Ms. Westervelt.
Yes, we didn't change anything in the student progression plan. We just made it easier to read, and now we just want to put it back on the website so that it's very clear and that everybody can understand K through 12 exactly what their children will be doing.
Oh, excellent. Thank you. Thank you for your work on this, team. Is there a motion to approve the Student Progression Plan?
I move to approve the student progression plan.
Is there a second? All those in favor of the Student Progression Plan state so by saying aye. Aye. Opposed? Passes unanimously. We're going to move on to board comments. Board members, anyone have a comment for today? Of course, get the mic. You can drop it too if it's a good comment.
Okay, I am fairly new, as you guys know, and we have spent 2 hours, over 2 hours, on petty, what I think is petty, things, when we could be spending our time, our energy, our money for this school on our children. And this is super sad. We need to stop. And I think that if we just take away our feelings and use logic and really get real with the situation, this does need to stop. And I think that if we start coming together, there's so much going on in the world right now, so much dividing, and I think that we need to come together for our kids and stop the nonsense. The small things when I'll just quickly say, when I was starting to get into the process of finding out what is going on, because I was new, a new parent, I looked and I compared how CCPS was treating our school compared to all the other charter schools in our area, because I wanted to see how, are we doing something wrong? Are you guys doing something wrong? What is going on? Go check it out yourself. We are being treated completely different than all the other schools in our area. And you ask yourself why. Because we're number one. And that's all I have to say.
That's a mic drop, by the way.
Well, I agree with that. I also think that the reason we're being singled out is that we are not following the slow acceptance of measures that are moving this country and this county legally and gradually toward communism through socialist measures. And I really hope that all of us look very, very carefully this month and this year to who we are electing to office here locally and beyond, because there are a lot of people who put R's behind their names and then get on school boards and vote this way and take measures this way to take down traditional entities that are threats to a socialist agenda.
Yeah, I just have two quick ones. First of all, I just wanted to say thank you to everyone who's here, that worked on everything this summer. Tons of work. You can tell, tons of work went into it. The folks that aren't here that, worked on it. As a board, we thank you for all your hard work. And then second, I just want to say that the day we received word that the motion to dismiss the Baird case was denied, that was a very, very good day for the school. Going to Mr. Hull's point, we are going forward now, going to have the opportunity to uncover everything. And you've seen just what we've uncovered just from, you know, a couple subpoenas and a lot of public records requests, and everything that is going to be uncovered in the next, I hope, 3-4 months. I think it's going to be very beneficial for this school.
Thank you. Again, thank you to my fellow board members for hanging in there and sticking it out, and to Mr. Hall, his team. The teachers, they're going to be coming back next week. We welcome them back. We are looking forward to an excellent school year. And to Ms. Eberson's point, I mean, I have brought it up at multiple board meetings, even asked the district, especially when the pandemic started. A lot of people were really hurting. People were, I know personally, losing jobs, and very difficult situation. Asked the district to, like, let's bury the hatchet. Let's move forward for the kids' sake. And it's just, to me, the more the information he references that gets out, it seems like the more aggressive the attacks are against us, and more of an attack to silence us. I mean, to disavow a website, that's absolutely absurd. And Mr. Fishbane references this hostile takeover website and says we have to disavow it. But if you look at it, it's posting documents and truth and facts. I guess they don't like that. I'm never going to disavow pursuing truth. So anyway, I'm looking forward to a great school year. I know my kids are really excited about getting back to school and seeing their friends and their teachers, and getting back to some normalcy. I really, truly hope people who are listening will take heart to what other board members have said, what Mr. Hull has said, what our public speakers have said today. And so we can get a clean slate and start fresh, and I think our teachers and our students deserve that. So with that said, this meeting is adjourned. Thank you for your time today.